This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we speak about the fact that insurance fraud is truly a violent crime and why a healthcare fraud trial resulted in a murder for hire of one of the government's key witnesses. In United States of America versus Louis Age Jr., Stanton Guillory, and Louis Age III, the United States Court of Appeal for the Fifth Circuit on April 25, 2025, dealt with the charge of murder for hire. The Fifth Circuit was faced with the appeal of a murder for hire conviction, and the defendants were convicted and each sentenced to terms of life imprisonment for their involvement in the murder for hire of Milton Womack, a federal witness in a healthcare fraud case. The history of the case began with an earlier healthcare fraud case in the Middle District of Louisiana. In August of 2011, a federal grand jury charged Louis Age Jr., Ayanna Age, Milton Womack, and others with conspiracy to commit healthcare fraud, conspiracy to receive and pay healthcare kickbacks, and making false statements to receive payments from Medicare. Age Jr. owned South Louisiana Home Healthcare Agency, which paid illegal kickbacks for patient referrals. Age Jr., while awaiting trial, hired Hilliard Fazand to represent Womack in the healthcare fraud case and gave Womack cash payments to be quiet and to cooperate. Womack later contacted defense attorney Michael Pfizer because he was not comfortable with Fazand and wanted his own lawyer. After Womack decided to cooperate with the prosecution, Age Jr. decided to kill Womack. In July of 2012, Age III, Wilson, and members of the Young Mafia Fellas gang, including Stanton Guillory, Raheem Jackson, and Brian Marjorie, shot and killed Womack. Guillory used a stolen Glock Model 23 firearm and a carjacked red Chevrolet Monte Carlo to commit the murder. Age III failed to pay Guillory the full $5,000 for the murder, leading to Guillory's arrest after a high-speed chase. Age Jr. sued Ayanna to take back rental properties he had given her and successfully tried to initiate a criminal case against her for embezzlement. Ayanna, regardless, testified against Age Jr. in the healthcare fraud case. In August of 2017, a federal grand jury in the Eastern District of Louisiana returned an 11-count indictment charging Age Jr., Age III, Guillory, and Wilson with multiple counts of obstructing justice in the healthcare fraud case, including the murder of Womack. The prosecution must demonstrate an agreement by two or more persons to commit murder for hire. The defendant's knowing and voluntary participation in the agreement and an overt act committed by any one of the conspirators in furtherance of the conspiratorial objective. The substantive offense of witness tampering criminalizes the act of killing or attempting to kill another person with the intent to prevent the attendance or testimony of any person in an official proceeding. And that's what they tried to do, and in fact did. The court admitted evidence of crimes, wrongs, and other bad acts intrinsic to the crimes charged. Evidence of Guillory's other criminal activity established his involvement and role in the murder for hire conspiracy. The district court correctly admitted the arson-related insurance fraud evidence as intrinsic to the charged offenses. The defendants tried to include the confrontation clause as part of their defense, but that clause of the U.S. Constitution guarantees a defendant's right to confront witnesses against them in a criminal prosecution, emphasizing that testimonial statements should be made by witnesses present in trial for cross-examination. If a witness is unavailable, their prior testimony can only be introduced if the defendant had an opportunity to cross-examine them previously. The clause aims to ensure reliable evidence through the process of cross-examination, which is considered a procedural guarantee rather than a substantive one. Of course, they couldn't construct or cross-examine the key witness because at their requirement and at their hand, he was dead. Defendants challenged the admission of Michael Pfizer's testimony regarding attorney-client communications with Womack, the deceased. The district court ruled that any communications Womack had with Pfizer in the presence of a third party, including the prosecution, are not privileged, and therefore the court affirmed the district court on all issues. In my opinion, the public and many judges believe that insurance fraud is a non-violent crime, and as a result, prosecutors are loath to prosecute insurance fraud. This case established that insurance fraud, because it is a very, very profitable crime, can easily turn violent, and when the U.S. DOJ started prosecuting the crime of health insurance fraud, the defendants entered into a conspiracy to kill the key government witness in the health insurance fraud case, only to find themselves also convicted of murder for hire and sentenced to life in prison. Insurance fraud is a major felony and should be prosecuted vigorously to avoid the type of murder for hire and conspiracy in this case, where the conspirators without honor did not even pay the fee required by the killers. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also receive access to the more than 5,050 blog postings. You can also subscribe to these videos on YouTube and rumble.com. They're free, and if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. Please tell your friends and colleagues about this blog and these videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance fraud, insurance law, and insurance claims, please consider for a small fee subscribing to my Substack publication. Thank you for your attention.